I'm Neil Davis, Senior Partner at Caddick Davies Solicitors. At Caddick Davies Solicitors, we specialise in the defence of drink driving offences. One of the offences which we specialise in is failing to provide an evidential specimen, either a specimen of breath, blood or urine. Now this is quite a serious offence as it attracts a mandatory 12-month period of disqualification and offer a longer period of disqualification. And whilst these offences are often dealt with by the court by way of a fine, they can also attract, in more serious cases, sentences of imprisonment. Now, a person can be required by a police officer to provide a specimen if they are suspected of an offence of drink driving, or in other cases where a moving traffic offence has been committed. Now, once that request is made, provided that the request is properly made, then a person must cooperate and provide a specimen. And if the person doesn't provide that specimen, and they don't have any reasonable excuse for not doing so, then the offence will be committed. Now, of course, there will be those cases in which a person, through no fault of their own, is unable to provide a specimen. For instance, in cases where a breath specimen is requested, for instance on the likes of a Lion Intoxilyzer 6000 UK, which is this device which we have here, it may be that the person uses their best endeavours to provide a breath specimen, but simply find themselves unable to do so. Now, in such cases, it may be that the reasons why a person can't provide a specimen amount to a reasonable excuse such that the offence hasn't been committed. Examples of that could include psychological or physiological reasons why a person is unable to provide that specimen. So, for instance, if a person suffers from asthma or chronic obstructive pulmonary disorder, they may have difficulty providing a sufficient volume of breath in order for the evidential breath test equipment to work properly. Now, if it can be shown that there is a genuine reason why the person hasn't been able to provide an evidential specimen, then that will amount in law to a reasonable excuse. And it is, in fact, in all cases for the prosecution to show that there wasn't a reasonable excuse. So once this is raised as an issue, the burden rests upon the prosecution to prove beyond reasonable doubt that there isn't a reasonable excuse. In other cases, it may be that the request made is for a specimen of blood. And in some cases, it may be that a person finds themselves unable to provide a specimen of blood because, for instance, they have a fear of needles or perhaps some other form of medical phobia. And in those cases, it can also be argued that there is a reasonable excuse. Similarly, in the context of urine specimens, it may be that whilst you're requested to provide a specimen of urine, that you simply can't go to the toilet. That could be owing to shy bladder syndrome, having issue with urinating in front of another person, or it could indeed be owing to some other physiological condition, such as prostate issues. Again, in these cases, it can be argued that if such reasons exist, that there is a reasonable excuse not to provide a specimen. If you find yourself investigated or charged with an offence of failing to provide a specimen, when you contact us, we will discuss with you the facts of your case and we will seek to establish whether or not you have had a reasonable excuse for failing to provide a specimen. It may be the case, for instance, if you've been requested to provide a specimen of breath on an evidential breath testing machine, that you don't know the reason as to why you couldn't provide a specimen. And in those cases, in appropriate cases, we will use our medical experts and we will also use our forensic toxicology experts to investigate the reasons why you were unable to provide that specimen. Beyond those issues of reasonable excuse as to why you couldn't provide a specimen, there can also be procedural arguments that can be advanced in these cases. And one of the main procedural arguments is that the police haven't provided an appropriate warning before requesting you to provide a specimen. The police are required in all cases, before making that request, to explain to you that if you fail to provide the specimen, you may be liable to criminal prosecution. And if that is not done, then that will, in law, amount to a defence. In other cases, it may even be that the police officer has conducted the procedure incorrectly so as to contribute to your failure to provide a specimen. And again, that would in many cases amount to a reasonable excuse. If you think any of the issues raised in this video are relevant to you, then please contact us in order that we can have a consultation with you, and we will fully advise you as to the options in your case.